Now, when I finish the manuscript I'm working on, I'm going to spend more time developing this analogy between psychotherapy and litigation. But there's, I believe, a deep truth there. And it's something that the judges themselves typically don't understand. In delaying enforcement, the judges thought they were being political. They were being political. They were also being politically wrong. But the delay that they implemented implicitly had this function to it of highlighting the moral issue and setting up proceedings in which the white Southerners, the oppressed, could see the cost, ultimately see the cost to themselves of behaving immorally. I regret to say that the court, in failing to understand what it was doing in Brown v. Board of Education, came to imagine that it succeeded because it was exerting command and control authority. In particular, the ambition in the abortion case in Roe v. Wade to immediately order a complete transformation of our social system about abortion was the court feeling its oats. Aha, we succeeded in Brown, and we succeeded in ordering this change. We can order whatever change we want. It's what they did in the Nixon tapes cases. It's what they did in Bush v. Gore. They overstated and understood the kind of power that they were using. And the power they were using was to structure what I've called an interdependent notion of authority, in which they had authority, but they also relied on others as having independent authority, and that is the president, the Congress, the Southern governors, the Southern district judges, and ultimately the white Southerners themselves, and the whites across the country. When we, living in the North, looked at those pictures, we suddenly said, this is going on in the South, in our country, and this is a disgrace. And we can't pretend that we're not responsible for this, because there are remedial steps that we could take, that is, passing these bills, that would improve the situation markedly. And if we don't pass those bills, if we're not part of the solution, we become part of the problem. So the whole country was engaged in the morality of this issue. Now, it's 8 o'clock. I had hoped in these remarks to talk about 2 other strands of litigation. I will do so instantaneously. I've already mentioned abortion. The court had an option in the abortion cases, which it did not take. The court decided Roe v. Wade and wrote its own abortion statute in 1973. Now, parenthetically and interestingly, when you read the opinion, I don't know how many of you have read Justice Blackmun's opinion in the abortion case, but I think it's fair to say, I certainly feel, it's a disgrace. And the reason it's a disgrace is not the result it comes to, but the reason that he gives. What he says in Roe v. Wade is, this is the doctor's right to decide whether to have an abortion, not the state. And the doctor has the right to decide for his pregnant patient, and I'm directly quoting Blackmun here. So all doctors become men in Roe v. Wade, his pregnant patient, not this person who is an independent actor on her own right. This is not a woman's right cases. Now, subsequently, 4 years later, the court corrected itself. The advocates informed the court about what was really at stake. And I heard Blackmun lecture maybe 20 years after Roe v. Wade was decided at the Yale Law School, and somebody asked him, why was he speaking of doctors' rights in Roe v. Wade? And he said, well, you know, I just didn't get it. You know, I was an unreconstructed male chauvinist, and I thought that was the right way to go. The women ultimately educated me. The sad thing is that the court didn't understand that it didn't understand. And how do you come to understand? You listen to people, but that takes time. But the court rushed in, decided the whole case. Now, you know, we may agree with the result that they came to, but the way they got there was terrible. And they had an alternative. The alternative was a case that they decided in 1971 called Veach v. the United States. kind of like Bob Bartlett. People don't know Bob Bartlett is the hero of the 1968 Act. And they don't know that Veatch is the right way that the court should have gone because they never heard of Veatch. Veatch was a doctor in the District of Columbia who performed an abortion after deciding that his patient's health, mental health, was threatened by her pregnancy. The District of Columbia authorities prosecuted him, and he was criminally convicted on the ground that the District of Columbia statute did not envision mental health, but only physical health. So he appealed to the Supreme Court. And what he said in the Supreme Court was the statute in the District of Columbia was void for vagueness. It's a standard legal rule and a very important one, that if you're dealing with a criminal statute and the moral blame that that comes with, the statute has to be very clear so that everybody can avoid violating the criminal law. And I must say, when you look at a statute that said, well, you can have an abortion, but only when a doctor says it's for your health, and you don't define, is it mental health, is it physical health, is it imminent death, well, what kind of health are we talking about? That strikes me as a pretty vague statute. The Supreme Court, in its wisdom, and this is 1971, Justice Black wrote the opinion for the court, actually for 8 members of the court. There was one dissenter, and that's Justice Douglas. But Black said, no, we look at this statute, it looks pretty clear to us. And it's pretty clear that it includes mental health. And it's pretty clear that the people who convicted Veatch understood that it was mental health, but that he just did a wrong thing. So we approve of the statute. It wasn't void for vagueness. And then he died, and Harlan died, and these kind of rocks in the court suddenly disappeared. And the new justices came on, including Justice Blackmun, who replaced Justice Black, believing in the command and control mode, as Blackmun particularly did in those days, and believing that Brown v. Board of Education was a success that the court accomplished kind of on its own, blind to history, simply said, well, we can't find the statute void for vagueness. Actually, Blackmun would have liked that, but Douglas said, you can't do that. You've got to bite the bullet, take the principle. And so he decided the whole issue. Now, if the court had gone the way of void for vagueness, in my judgment, this is a political judgment, they would have done what happened in Canada. The Canadian Supreme Court in 1988 ruled that its abortion restriction statute was void for vagueness, and sent it back to the legislature. And the implication was this wasn't the end of the conversation. It was the beginning of a conversation. And the conversation would take place between various state legislatures and the court on this issue. In 1973, most of the statute, the abortion restrictions in the United States had been adopted 50 or 60 years earlier, or even longer, in the 19th century. So the court, in effect, was wiping the books clean if they had gone with vagueness and challenging the legislatures, so come up with a more precise agenda. What would have happened is that in many states, the women's lobby was strong enough to block any legislation. And in other states, when they're not strong enough to block legislation, new statutes would be passed and come back up to the Supreme Court. And the Supreme Court would do what it does in many cases. They would look at it and say, you know, this is still pretty vague. It's vague on this. You can find vagueness anytime you want it. If what your goal is to stimulate conversation, interaction, and that's why you choose that result. Now, actually, what's happened in Canada, the court said there was one dissenter. She was the only woman justice. She said there's an issue of rights and principles and equality here, and she was right. And we should invalidate the abortion statute on grounds of principle, she said. The other justices didn't agree with her. Instead, they went the way I would have gone, which is to say, no, the statute is, these issues of principles are here, but they're in the background at the moment. The statute on its face is void for vagueness. We're going to wipe them all out. And if a legislature wants restrictions, let them try again. And we won't guarantee you one way or the other. What's happened in Canada is that the women's lobby has not been strong enough to get a free abortion statute that they want, but they have been strong enough to block any legislation restricting abortion. And in legislatures, it's always easier to block legislation than to pass legislation. So what the court in Canada, in effect, has done is heighten the political power of an oppressed group, the women, but not commanded everybody to put the women on top and to appear to be oppressing the men, instead moving toward an interdependent relationship. Now, there's no guarantee here, but in any event, if the court thinks of itself as stimulating conversation, it would behave very differently than if the court thinks of itself as, by and large, it does, which is deciding issues. I want to talk briefly about one other piece of legislation, and that's contemporary, and that's the rights of gays and lesbians. The court, once again, is behaving with the same acuity that they did in Brown v. Board of Education, but they don't know it. They had an opportunity in 1986, in a case that came from Georgia, to overturn the Georgia statute that criminalized same-sex sexual relationships. By a 5-4 vote in a case called Bowers v. Hardwick, the court decided to uphold the constitutionality of the state statute. And in the course of the opinions in that case, in a concurrence by Justice Berger, he said, well, homosexuals have been despised from the beginning of civilization. They are guilty of a crime which cannot be given a name, which is to say we're wiping homosexual people out of the status of human beings because that's the tradition and that's what the majority wanted to do. That's what happened to black people. That should have alerted the court to the fact that they were dealing with an issue where they should have intervened to protect these people, not to affirm their oppression. But the court misunderstood that by a 5-4 vote. Okay, that's 1986. They did wrong, very wrong in that case. But they corrected themselves in 2003 in a case from Texas called Lawrence v. Texas. And in that case, one of the things the court did was to announce that the Bowers case was wrong today, the court said, and it was wrong the day that it was decided, and we hereby overrule it. That's kind of unusual for the court to overrule itself, but they explicitly and plainly and dramatically did. They also wrote an opinion, this is by Justice Kennedy, that is a model of obfuscation and confusion. Justice Scalia dissented in the case, saying you should do what you did in Bowers v. Hardwick. And if you read the court's opinion, you don't know why they overturned the statute. There is no logic to it. One of the things that Kennedy said in his opinion was, we're not dealing with same-sex marriages here. In his dissent in 2003, Scalia said, don't bet on it. Unless logic has left the regime of the Supreme Court and reason knows no place on this bench, there's a necessary implication that to overturn this statute means to approve same-sex marriage. He has a wonderful penchant for defeating himself, for reading the majority opinion as broadly as he can think of, instead of trying to distinguish it. In any event, the opinion itself on Kennedy's part was, as I say, a model of obfuscation. You didn't know why he overturned the statute. All you knew was that he overruled Bowers and overturned the Texas statute. But was it because these were adults who have a right to privacy, to do what they want? Was it because they were adults who were having sexual relations in their own home, so that there was a right to privacy? Or was it because to criminalize their sexual relations demeans their dignity and treats them as less than equal, which he also said? So there was just a mix of rationales, and then he shut up. And all you knew was the Texas statute was invalid. His silence, and not just him, the entire Supreme Court, the basis for the silence was a political judgment. The advocates for gay and lesbian rights knew that the Supreme Court was a very unsympathetic forum to them, and they decided to stay as far away as they could from federal forums and instead pursue litigation in state courts. And so they did. They turned to a number of state courts. The first state court that they turned to was Massachusetts. Approximately 4 months after the Texas case was decided by the U.S. Supreme Court, the Massachusetts state court said that their constitution was more generous than the U.S. Constitution, and as a matter of state constitutional law, same-sex marriages were required. There was a right to same-sex marriage. Very stunning, but by a state court and a state constitution. Now, there is this crucial difference. Oh, goodness, I'm violating my rule, but I'll even talk faster. There was this crucial difference between the state ruling and the federal ruling, and that is a ruling on the federal constitution is virtually impossible to overturn except by having the court change its own mind. You can't overturn a ruling on the federal constitution because it's impossible to amend our constitution. It requires such high majority support, requires 3/4 of the states to approve what 2/3 of the Senate and House have approved. So you look at our document, and there are, 26, 27 amendments, and most of them, not all. Well, you take away the first 10 amendments, that's the Bill of Rights, and you virtually have an unamendable and an unamended document. But that's not true for state constitutions. It's very easy to amend state constitutions. Massachusetts was one of the more complicated, and that's only because the quickest that you could go would take about 5 years. But there was an easy way for a majority in the state to overrule a ruling of the state court. The consequence is that a state court constitutional ruling is the beginning of a conversation, not the end. And the fact that initially, in response to the Massachusetts court's ruling, there were expressions of outrage by legislators in Massachusetts and threats to amend the Constitution, but these legislators never introduced legislation. They fell silent. This is a case where silence, in my judgment, is acquiescence. So you had, in effect, participation by representatives of the people in evaluating the court's result. Today, 18 states in the United States, plus the District of Columbia, permit same-sex marriage. Approximately half of those states came from rulings by state courts on the state constitution, and half were actions by legislatures, which is amazing, when you think of it, in terms of the change of attitudes. New York is a wonderful example. The New York Supreme Court said, under our Constitution, there is no right to same-sex marriage. The next year, the New York legislature gave a right to same-sex marriage. So again, we're talking about shared authority, interdependence, a conversation, not a single command and controlled ruler. In the last 2 months, there have been 3 United States district courts which have reached the federal constitutional question. I won't go into detail about them, but it's taken them 10 years to reach the federal constitutional issue. Those decisions, the decisions are from Utah, Oklahoma, and Virginia. Those cases are on appeal now. It may be that they'll be affirmed. It may be that they'll be reversed by the courts of appeal. I don't know what the Supreme Court would do, but it seems to me that we have gone through a process of moral reimagining, of moral correction, that the legislation and the legislative action has already accomplished. And my view, at least, of the actions of the Supreme Court say there's no hard and fast rule when enough time has elapsed, but it's been enough time. The court could wait a little more too. There are ways to avoid the court taking jurisdiction. I mean, let's say that there's a split in the courts of appeals. The court doesn't have to take the case. Let's say all the Court of Appeals provide for a right, a federal right to same-sex marriage. Probably the court would take the case, but we don't know. The important thing is a conversation has taken place, and that's the heart of the matter, and the court doesn't understand that that's what it's been doing. They have been part of the politics of the matter, but I hope that you have an understanding of what they've been doing that I've been trying to communicate. And when I write this manuscript, I hope maybe a judge or two will have a different understanding for what they're doing. We'll see. But in any event, I apologize for taking you so long, but I couldn't resist telling you about Bob Bartlett and my sitting in the Senate gallery, and that took some time. And I couldn't resist talking about all of these cases, too. So thank you for your attention. I'm very flattered by it, and I hope that you come away thinking, well, there's some plausibility to what he's saying, even though, as I warned you at the beginning of my lecture yesterday, my view is not the majority view among constitutional law scholars, much less judges. In fact, I would say I'm so much the minority view that maybe I stand alone, but not here in Argentina. Thank you for your company.
¿Preguntas? Mariela? Sí. Do you think that President Bartlett in the West Wing, Martin Sheen, that's
was named after Bob Bartlett?
Yeah, maybe. So.
It never occurred to me.
All right, there you go.
It could well be.
It's the best homage.
Me voy a aprovechar y voy a hacer dos preguntas, tratando de que sean rápidas. La primera pregunta es para clarificar un poco el punto del paper, y tiene que ver con cierta sensación de que se promueve para este tipo de conflictos una intervención de la Corte que no sea de control y comando, sino más bien una intervención de la Corte parecida a la del segundo Brown, en donde la Corte parece promover una conversación, por decirlo así, moviendo hacia una función terapéutica, si se quiere, dentro de un conflicto entre partes que están confrontadas de una manera trágica casi, ¿no? Y en esto, uno de los ejemplos que usted da precisamente es lo que pasa después de Brown II y lo que pasa después de que el Congreso decide empezar a cortar los fondos a el sur o a los estados del sur, que es una decisión claramente de control y de mando del Congreso, en comparación con una decisión diferente de la Corte en Brown II, en donde, por el contrario, dice deliberative speed, ¿no? Peter Rosenfeld compara los dos momentos y muestra el efecto enorme que tiene la segunda, que tiene el actuar del Congreso frente al efecto mínimo que tiene el actuar de la Corte, en términos de cuánta desegregación efectiva ocurre, ¿no? Entonces esto pareciera ser, a menos que uno encuentre un contacto o un vínculo entre la decisión de la Corte y la ley de derechos civiles, si uno lo separa, con lo que se encuentra es una decisión de control y comando tiene efectos y una decisión de este tipo conversacional tiene muy pocos efectos concretos en términos de conseguir el objetivo de la desegregación. Mi segunda pregunta tiene que ver más con esto de la función de psicoterapia dentro de la Corte, que acerca, que les proporciona un lugar seguro a las partes en donde puedan explicarse a sí mismos, en donde puedan conversar. Pero esto ocurre entre muy pocos sujetos, que no siempre son los más representativos de dos clases que confrontan fuertemente a nivel social. Entonces, ¿en qué sentido esta función psicoterapéutica, por decirlo así, es socialmente relevante? Porque de alguna manera esa explicación...
Well, these are large and important questions. Your first question, I'll put it in this way, and you tell me if I'm distorting what you're saying, but you're suggesting that the Congress in the '64 Act exerted command and control authority that the court didn't. But in fact, they didn't, if you look at it carefully. They didn't on two grounds. One, there was no law, no southern state was obliged to keep federal money. The southern states, and many of them did following the 1964 Act, say, we don't want the southern money, the federal money. If you're going to use that money as a lever to force us to desegregate our schools, we're going to say, keep your dirty money. And in fact, in one state, in Virginia, many counties actually shut down the public school systems. Now, ultimately, that was dealt with by the courts in a complicated kind of way. But it was not a command and control. It was, here's a consequence that we're going to impose on you if you act in this way, but it's up to you to decide whether you want the consequence. That's not the command and control mode that courts think of. You know, they don't usually say, except they did in Brown, say to people, well, here's the law, but if you don't want to obey it, don't bother. So there is a fundamental kind of difference. And then there's a second difference, and that is that the senators and the members of the House of Representatives are popularly elected. Now, you know, we may know that this doesn't really mean, you know, full democratic participation, but the ordinary person, and we are also ordinary people, think of the authority of courts as different from the authority of legislators because they are elected. And when they vote in a particular way, they hold themselves vulnerable to being thrown out of office. You know, I always tell my first-year students, when I disagree with my senator, I see myself as going up and saying to him, damn you, you know, how could you take that really stupid position? I'm going to vote against you in the next election, and I'm going to tell all my friends and mobilize to get rid of you. Now, you know, that's a conversation. It's not a polite conversation, but it's something to say. If I were to say this to a judge who ruled against me, you know, if I were to stand up the next day in court and say, damn you, I'm going to do what I can to see that you're impeached, I'd be sent to jail right away, because that's contempt of court. Instead, I tell my first-year students, I go into it this way, I say, what are you supposed to do when a judge rules against you and you know that the law is on your side and the judge is wrong? What are you supposed to do? And the students say, well, you disagree with the judge, or you explain, or you urge the judge to reduce, you know, to change himself. No, no, and no. What are you supposed to do? You're supposed to say, thank you, Your Honor, for a lawless action and one that hurt me and hurt my client, because that's the standard way of thinking of judging. Well, that's what I'm fighting. And what Brown does is to give the illustration of a different deployment of authority that actually is required given what the court was trying to do, which is to change from a relationship of dominance and submission to equality. For a long time when I was writing this, I really only had one example. You know, because courts fall, you know, kind of instinctively into a command mode. But I had Brown, and I used Brown for all that it was worth, maybe more than it was worth. Well, I have two examples now. I have the gay rights cases, in which the court is doing the same thing without understanding, as in Brown v. Board of Education, but they're drawn to the same result. So now I have two examples in which the court has behaved properly. Well, that's more than one, double, indeed. But it is unusual. And that's your second question, the kind of therapeutic impact. What I am trying to say to judges and to the legal academy and to you generally is there are these parallels with psychotherapy. And if you begin by saying that what your goal is to dissuade the oppressor, and in fact, to show the oppressor that he's hurting himself, and I think that is true for anybody who's involved in this, in any role. Think of yourself as a psychotherapist and not as a commander. Now, I want to use one other example. In psychoanalysis, the inventor of psychoanalysis, who essentially systematized, didn't discover the unconscious, but tried to talk systematically about it, was Sigmund Freud. He has a huge body of work.
Estos últimos conceptos que mencionaste, lo de shared authority, conversation, interdependence, me parecen conceptos muy interesantes para la vida constitucional y democrática de cualquier país. Y se me ocurrió si tal vez estos conceptos son más fáciles de aplicar en un país con una constitución no codificada, como en el caso del Reino Unido.
Well, you know, it's hard enough for me to understand my own country, the United States. And I really, you know, I've dabbled, I've read, I've talked to scholars like Martine and Roberto about different jurisdictions. But I have restricted my attention to the United States because, as I say, you know, it's hard enough for me to understand that place. Now, there are interesting things happening in other jurisdictions, very interesting things. There's an Argentine constitution, there's litigative processes, there are a lot of similarities, and I invite you in Argentina to draw your own parallels between what I've described in the United States and here. Maybe there are good ones, maybe not. What's happened in the United Kingdom recently is quite fascinating. The idea of written constitutions and judicial interpretation and even enforcement of those constitutions has spread through the Western world. So the United Kingdom now has a constitution. It's not the English written constitution, not the English constitution, it's the European Union's constitution. And the structure of authority in Europe is that if somebody brings a constitutional claim under the European Union Constitution to an English court, to the English Supreme Court, which they just invented in response to this, and they get ruled either for or against, there's an appeal that can be lodged to the European Court of Justice. So things are changing, and the opportunities for intervention are more. And one of my hopes is that this wonderful complex relationship between the European Union, which doesn't speak as a commander and controller in the sense that the European Union commands and controls its members, and yet it has the document there. So they're constantly kind of impelled to play both ends against the middle. So maybe there's a fruitful audience there for the kind of thing that I'm talking about, given the complexity of their mission, which is to be in possession of a written constitution, but not to exercise command and control authority over the member states, which retain their own authority. It's just very fascinating to see, but it's very young. I mean, we're talking the last really 10 years, 15 years.
¿Qué hacemos ahí todos?
¿Puedo hablar en inglés? Oh, bueno.
Sí, sí, como quieras, lo que quieras. De la manera que-
Thank you.
I wasn't able to make it yesterday, so I don't understand the first concept you mentioned about the Kurt's rule being essentially negative. Why is that?
Well, actually, I didn't talk about that.
No, you didn't, but you mentioned it.
Yes, yes. It's essentially negative in free speech matters and free religion. It's not essentially negative in equal protection cases. They can't accomplish what they want by saying, don't do that. It's not what they're after. When government intervenes to regulate speech, the court can accomplish its constitutional purpose of saying, don't interfere with speech. This person can publish what he wants. Or in campaign financing, the court says to the Congress, you can't pass this statute restricting individual corporation donations. And it's easy to enforce. I mean, it may be wrong, but there's not an enforcement problem. But if instead the court was dealing with a case of equality, of equal protection, their goal is very different. It's not, it only is partially stop doing that. It's also, and start doing the right thing. If there's no more response to campaign financing after Citizens United, the court doesn't care, that's fine. If there's no response after Brown v. Board of Education to segregated education, the court is saying, this is not what we were talking about. We wanted you to stop what you were doing, but recast your relations on a basis of mutual respect and equality. And that's much more complicated. And that involves all of these kind of psychotherapeutic analogies and delays and conversation. And the complexity of it is why I love it so much. It's too easy if it's simple, even if it's right.
There was a question there.
I don't want to say a problem because it's more like an issue, but you are leaving out lawyers in your theory. You're not giving place to lawyers. With a psychotherapist, you have the patient and the psychotherapist, and they talk. Well, one talks, the other listens. But in court, you have lawyers. And they kind of break with that scheme of the one that talks and the one that listens and then gives an advice or a ruling in this case. And that kind of bothers me. What's the place of the lawyer in all your theory?
Well, you're helpful to me in pointing this out, and I never used the word lawyer in 2 days of lecture here. And I may be too simplistic in what I'm saying, but my view of the lawyer's role is the lawyers are obliged to speak on behalf of their clients. It's their clients that they embody. It's not their personal views. So Thurgood Marshall, the lawyers in Brown v. Board of Education for the Southern States, John W. Davis, spoke on behalf of his clients and their support for race segregation, and he brought into the court kind of the respectable arguments that could be made. But he did, he didn't come in and say, look, we hate blacks, they're dirty and they smell bad, and that's why we want them out of class. But these issues lurked behind the polite words that were representative of what the clients could say. And let me say, the lawyers for the states that forbid same-sex marriage are having quite an interesting impact because, again, they can't say, well, we hate homosexuals, that's what it is, and they're dirty and they smell bad. So they have to come up with respectable sounding arguments, and, they can't come up with anything that sounds respectable, which has its impact on their clients. Their clients say, well, is this the best argument you could make? Well, I could say they smell bad, but that wouldn't help. So there's learning that goes on. Now, on the other side, the other lawyer for the black folks in Brown v. Board of Education, the principal lawyer was Thurgood Marshall, and he had a problem. He had a problem because overwhelmingly the blacks living in the South were afraid to become litigants because they would be physically attacked, even killed. That's the way things worked in the South. So he managed to recruit a small group of very brave black people from the South, including, he was very lucky to find somebody named Linda Brown for the symbolism of it. It's like the right to marriage case that the Supreme Court finally decided called Loving against Virginia. And my half-joking view is, well, the court was waiting to find a plaintiff named Loving to say, you're opposing Loving to the state of Virginia. But he had a problem in terms of who were his clients, but he understood the depth of the fears. And he did speak for the black population. So there was learning that goes on through the mouth of lawyers. Lawyers play a crucial role. And part of their crucial role is only making respectable arguments, which heightens the question, is this a good enough argument? Not just to the judges, but to the general population. So there is an important role for lawyers in my scheme, but I just, until you prompted me to do so, didn't articulate it. Thank you.
Dean Saba has a question.
In order for you to rest, I will speak in English.
That's good.
Excuse for my English. I know almost nothing about psychoanalysis. I'm probably the only one in the room who has not been at the shrink.
It shows.
3. But we are a minority.
I thought everybody in Argentina.
No, that's why I'm saying this. So I confess my complete ignorance. But I want to refer to this the interdependence approach. And my question is whether it assumes that there is some level of equality in the parties that are involved in this interdependence relationship.
Right.
Because, I mean, by definition, all the situations you described, I mean, gays, women, people with disabilities, blacks, are minorities that are subjugated by a powerful majority.
Right.
And let's take the model of the resending the decision that is sent by the court in Canada to Congress. I like to trust in that process, but I have the feeling that the majority may insist and may exert the power that it's exerting on the minority and continue. So I feel comfortable with this idea of, giving some space for seeing if we can solve the problem but at some point the interdependence approach doesn't work.
Well, you're quite right that there is an optimistic assumption that lies behind my embrace of this idea of conversation, of developing self-knowledge, of being able to appeal to fairness and equality as the basic organizing principles. If you live in a country in which there is no commitment at all to those values, my scheme doesn't work. But in those countries, it seems to me, you are locked into relations of dominance and submission. By my lights, those are countries that misunderstand the essential moral principle of our life together, which is that we are all equals and that we should treat one another with mutual respect. That doesn't mean, and again, as I've said before, my knowledge is the United States. I know little bits and pieces of other countries. In the United States, there have been long periods of time when there's been terrible injustices. I mean, the period from 11 years after the Civil War until 1939 was a period of terrible oppression on the part of all of these groups that we're talking about. I continue to believe that the ideals of equality and mutual respect were not lost, but they were in eclipse. What's a court to do when it finds itself in an historic era in which public faith in these virtues, in these principles, has been lost? Well, if it ultimately comes to that, if the court intervenes and then intervenes again and then intervenes again, and the majority keeps doing the same thing, there comes a point at which the principle is defeated. Now, at that point, maybe the court can say, well, we've been patient long enough, stop it, you must do it. But who's to say that the majority is going to do that after all this time? So I think in what you have in mind, we're talking about an irremediable failure. And I have nothing to offer an irremediable failure except to say, realize that what you're doing is deeply immoral. And reform, and that turns me into a prophet in the wilderness. But my hope is, and I must say, my understanding of Argentine history, as complicated as your history is, but when I first knew you, the country had overthrown the junta, the worst of the dictatorship in at least a long period of time, and there was a rebirth in democratic ideals, and the courts were part of that rebirth, and you as then young lawyers, and then the young lawyers that you're training, are imbued with that idea. Now, is Argentina a democratic place? Well, you had the court packing, you had a lot of things that look the other way. But Argentine history, it seems to me, speaks to the existence of this commitment to ideals of democracy and equality. And if you keep appealing to those and you keep showing the populace how they are violating those, I do have confidence that ultimately justice will prevail. But the one thing I do think I know is that to say that justice will prevail only when a court orders people to behave justly is just useless. It's an admission of defeat whenever it becomes, and warfare. And in many ways, our social life lives at the edge of warfare. You know, it's very complicated being in relation with other people and accommodating yourself to other people. But I'm optimistic in this way too. I hope I'm right about Argentina. Your history doesn't contradict my optimism. On the other hand, it doesn't completely support my optimism. But then that's true in the United States too. Except in the last 50 or 60 years, we have been making amazing, I mean, you know, gay people, for example, say, we should have been marrying years ago. We should have had respect. There shouldn't have been a criminal statute. And that's all true. And it's comfortable for me to say, well, but look at the long run, you know. John Maynard Keynes said, in the long run, we're all dead. Yes, right. And that's true. But I think of myself, well, and it may be too narrow in this way. I mentioned yesterday that I am a deeply identified Jew. The status of Jews in the United States has dramatically changed, even in my lifetime, and certainly comparing my lifetime to my father's lifetime. Now, it's very easy for me to say, oh, well, things are good for the Jews in the United States now, and therefore they're good for everybody. Things are better for the Jews in the United States now than they are for lots of formerly oppressed people. But having said that, you know, I remember when I was a young man running into anti-Semitism, being told by the girlfriend of my roommate that when I visited her grandmother in Northern Virginia, about half an hour drive from her house, where they were vacationing, that I would be the first Jew ever to walk into her house. And not to be surprised if she throws me out. Well, that doesn't happen today. You know, her grandmother probably wouldn't embrace me as a Jew. But so there is some progress. I hope I'm not overstating it because of my personal experience. But there is my personal experience. I don't know.
All right. Just one final thing. You never taught any sentencing clinic or procedure, or because you have all these ideas about the void for vagueness, the right confusing decision, or the issue about the state constitution, in order to get the conversation going. You identified those artifacts,
right?
But have you ever put them into a training thing for judges or lawyers? Or
Well,
are you planning to?
I have had some involvement in the clinic program at Yale, which is a great program. These issues that you identify, I have taught at various times in my career the rights of mentally disabled people. Right. And it's in that context.
But that's substance, right?
Well, but the sentencing issues that you raise are, I mean, I plan to deal with them in this manuscript. When I try and identify, are there other groups in America today who are deeply oppressed and subordinated, the top of my list are prisoners. And what's oppressive to prisoners, most oppressive, you can find in sentencing practices. In my view, if I were on the Supreme Court, I would strike down the following sentencing practices in the United States. The first, the death penalty. The death penalty, more than any other, symbolically, even though it isn't much used, treats human beings as outside the human race. And that's the test for me of subordination that has to be undone. Now, here's a situation where the Supreme Court can say no. They just say, don't kill people, and they can affect that. But it's not just the death penalty. Another sentencing provision has become very popular in the United States, and that is lifetime confinement without possibility of parole. Now, when you think about it for a minute, what you're saying is this person never can change, never can be rehabilitated, and that's where the mental illness issue comes in, so that they can rejoin the human race. It's another way of excluding them from humanity, and that's the reason to stop that. I'm not saying that and you're just struggling with this with the revision of your penal code. I'm not saying that you can't intervene coercively with someone who has violated the physical safety or bank robbers or bad people in this way, but that you have to give them the opportunity to rejoin the free population. Because if you don't offer them the opportunity, you are treating them as inhuman, as not part of the human community. In the United States, we have abandoned the so-called rehabilitative ideal. And that's what life confinement without possibility of parole means. You're non-rehabilitatable. My view is we should act on the assumption that everybody is rehabilitatable, but that doesn't mean we should be foolish. We should blind our eyes to evidence of people who say, I'm going to go out tomorrow and kill more people. I can't wait. We can look for evidence of rehabilitation, but we must look for evidence of rehabilitation. So that sentencing practice should be ended. Then solitary confinement is another way of treating human beings as detritus, as garbage, as not part of the human race. We do this in lots of ways in prisons, and we particularly do it at the intersection of mental health powers and prisons. What has happened now in about 25 states is that over the past decade, they have passed statutes which provide that a sexual offender, and sexual offenders are dehumanized worse than anybody, that sexual offenders at the end of their prison term, when they have been given fixed terms, can be examined, it doesn't even have to be a psychiatrist, by somebody who makes a finding not that they're mentally ill, but that they're likely to offend again. And if they're likely to offend again, you can then, for complete lifetimes, imprison them in mental institutions, but without a finding of mental illness. So this, again, is dehumanizing sexual offenders. Oh, and there's one other thing. I knew I forgot something that applies to all convicted criminals, and that is that when you have served your term, and when you are either paroled or your term has ended and you go back into the free population, in every state in the country, it's virtually impossible for a convicted felon to vote, no matter that he or she has served their time. Again, to say that you're not entitled to vote is to say you're not part of the human community. So you got to strike that down. And you have to strike down these fake mental health statutes. There's a lot of work for lawyers and for judges to accomplish with regard to prisoners. And they all tie in, I think, to what you're talking about in terms of sentencing, practicing. Yeah, that's right. That's right.
Okay. Otra vez, muchísimas gracias. Oh, yeah.
Can I say just one word? I have used the service of the translators only in a very limited way, but I must compliment the translators on the excellence of their work from Spanish into English, and I assume that they're just as good on English into Spanish. So thank you, and we all appreciate what you have done.
Entonces, acompáñenme a agradecer a las traductoras. Bueno, y agradecemos enormemente a la universidad y por supuesto al profesor Burt por estar con nosotros una vez más. Muchas gracias a todos ustedes.